The courts in the US do apply equity to license IP, even if not properly documented, even if there was no contract, no use of the word license. For example, let's say I pay you to create software code. I pay you $1 million to create a software program. We never sign a contract. We don't have a contract, so whoever created the code, let's say this vendor, is the owner, the initial owner of the copyright. There's nothing written in writing. So what happens? Am I out of luck because I didn't get a contract? I didn't get a license? The owner of the code has the exclusive rights to that. That's the kind of situation that the courts apply an implied license, where it's an equitable remedy that the courts say, you know what? They paid for it. When you give somebody permission to use intellectual property, even if there's no written license, know that you may be deemed to be giving an implied license. As a licensor, as the owner of IP, I want to be really careful about that. I don't want random implied licenses out there of people using things and not knowing exactly what the terms are, when does it expire, any of those details. Can they transfer it? Can they assign it? We don't know because it's a soft and fuzzy kind of concept when you're getting into equitable licenses and implied licenses. The better practice is just be really careful. Make sure when you're talking about IP that you are doing written rights, granting written rights to people and keeping it precise, documented, do it properly. If you sell goods, you don't have a contract, it's not the end of the world. You've got the Uniform Commercial Code, you're buying a widget, you paid me, it's okay. I don't sweat too much about that if it's not a massive risk or scale. But when it comes to IP and implied licenses, that's very scary. Do be very proactive to prevent that from happening.